Hello aspirants, welcome to Grace IS. So today in the series of Indian polity, since from past few days we have been taking classes on Indian polity, on the various topic of Indian polity. So today we had come up with a very important topic, extremely important topic of Indian polity, that is preamble. So we'll look into the both prelims and mains perspective, because preamble is important for both your prelims and mains. Very importantly for prelims, lot of question being asked every year from the chapter of preamble. At least one questions every alternative year or repeatedly every year you will be getting from this chapter of preamble. So in the chapter of preamble, we'll be looking about that what is preamble, what is the meaning and definition of preamble. So let's look into the overview of the chapter, what we are going to discuss today. The meaning of preamble. We'll look into the nature of Indian preamble, its purpose, and then we'll look into the whether Indian preamble is part of constitution. We'll also look into whether preamble can be amended. So preamble, since it is a quite big chapter, and we'll also be looking not only from the prelims perspective but also from the mains perspective simultaneously. So we have divided the chapter of preamble. Today these are the topics we'll be taking care of, and tomorrow we'll come up with an preamble part 2, where we'll be discussing about the various terms mentioned in the preamble. I hope almost all of you would have some knowledge about the preamble. You would have gone through the preamble and you know what are the ingredients of preamble. So those ingredients, those the words which are being mentioned in the preamble will be looking tomorrow. So today we will stick to these topics: the meaning, nature, purpose, the part of whether it is a part of preamble, and whether the preamble can be amended, and we'll also look few prelims questions. As I have mentioned already that preamble is very important, and almost every year you will be getting questions from preamble. Sometime 2 or 3 questions you will be getting directly from the preamble. So, and very easily you can handle these questions. So we have also included few questions from the preamble. So let's look into one by one. So we'll start with the preamble. First of all, we should know what is preamble. So just read out the preamble. Yes, the preamble. We the people of India, having solemnly resolved to constitute India into secular. So please mindful of each term, because the questions being asked from these terms also. So what is the ingredient or what are included in the preamble? We the people of India solemnly resolved India into sovereign, socialist, secular, democratic republic. So 5 terms being mentioned here. Be careful about all these terms. Then, and to secure to all its citizens justice, liberty, equality and fraternity. Justice of social, economic and political, right? So justice also very minutely you should observe and study preamble, because very minute details being asked in the prelims question. Justice of social, economic and political. Liberty of thought, expression, belief, faith and worship. Each of these terms are very important. Equality of status and of opportunity, and to promote among them all fraternity. assuring the dignity of the individual and the unity and integrity of the nation. So whatever the line I have underlined, whatever the line I have underlined, you can be more focused about these terms: unity, integrity, fraternity, dignity of the people. And in our Constituent Assembly, 26th day, 26th November 1949, this is the date of adoption, right? Adoption and enactment. So be careful about all these terms, as I keep on repeating, because they are very, very important from the prelims perspective. A little bit of here and there and you will mark the question wrong. So be careful about these words. Adopted and enacted and given to ourselves this constitutions. So lot of questions in prelims you will be able to solve if you have the entire idea of the preamble. If you have read the preamble with minute details, a lot of questions you will be able to solve from the preamble, right? So that's the reason you have to be very careful about that, these words being mentioned. I hope till here you got some idea that what is the ingredients in the preamble, what the preamble basically has content, right? So now we'll look into the meaning and definition of preamble. Like, what do you mean if somebody says that, you know, we have a preamble of constitution? What do you mean by that? What is a preamble? So preamble is basically, it's like a prelude. It's prelude. It's introduction. It's introduction to the constitution. It's prelude. Prelude means something, you know, what you are going to get. It's kind of an introduction. Something you are being sent, you are being given an overview that in the class, like just in the class, you know, I mentioned you that, you know, in the class, this is what we are going to talk about. We are going to talk about the preamble. In the preamble, what we are going to talk about, isn't it? I given you an introduction. I given you a prelude of the session, that basically what will you expect in the session. That is what called preamble. So it is like an introduction. It's like a prelude to the constitution. It's like an index. In your book, you will have the index front page where you will know what are the chapters, and in the chapters, many a time they would have mentioned details of the chapters. Within the chapter, what you will be getting, what you will be studying. So that is what index of the book. It is the summary or bird's eye view of the preamble. So there's a big book, right? Constitution is a huge book consisting of 395 articles and 25 parts, isn't it? So many schedules, 12 schedules. So there's a lot of things inside the Constitution. It's a quite detailed book, bulky book. So the preambles gives you an overview of the entire constitutions, isn't it? A summary of the constitution, what you will be expecting inside the constitution, why the constitution is being meant, the purpose of the constitution, the objective of the constitution, isn't it? You will get it when you read the preamble, the purpose, objective of the constitution, what is there inside the constitution, a summary, bird's eye view, isn't it? When a bird can see a long distance, when you see from the top, isn't it? Aeroplane view, like you can see a good area or a huge amount of area from the top, isn't it? So that is called bird's eye view. So entire constitution you can see when you read the preamble, when you study the preamble. So that's, it gives a bird eye view. It's the statutory recital of the ideas and aspirations of the people. So, you know that we were under the British and we had suffered a lot. We had no rights, we were being suppressed. So, the people of India, they had certain kind of aspirations that when India become an independent, what kind of society or what kind of nation will be having, right? So, those ideas and aspirations, the ideas that we want a democratic country, isn't it? Democratic, we want a sovereign country, sovereign, we want democratic, sovereign, republic country where the head of the state will be an elected one, isn't it? So we want a sovereign country, we want a democratic country, we want a republican country, and later on we also added socialist and secular. So these are the ideals of the nation, you know, what type of nation or what type of country or what type of society we want. And the aspirations of the people, aspirations, the aspirations, we want justice, we want liberty, we want liberty, we want justice, we want liberty, we want equality, we want fraternity. Now all these terms will be dealing in detailed manner, so you'll get the clarity about each of these terms, and most of the terms, the meaning you would be knowing. So that is what we had, certain ideals, that what type of society we want, and as a people we had certain aspirations. So we wanted society which is more just, which provide justice, which provide, you know, liberty, freedom, we provide equality, equality of status and opportunity, fraternity, of sense of belonging to one nation, brotherhood, right? So those, it is a statutory recital. When we say statutory recital, something, statutory means statute. It comes from the statute. Statute means something law, isn't it? A law made by parliament. A law made by parliament. So it's a statutory recitals because constitution is basically a law, supreme law of the land, isn't it? We have already discussed how it is different from the ordinary law. So it's a supreme law of the nation. Just like a law, it was also made by the Constituent Assembly, right? It was passed and it was enacted by the Constituent Assembly. So preamble is nothing but the statutory recitals. Statutory recitals means those aspirations has been given in the form of law, right? So constitution is a law and it is the supreme law of the land. So those things being made part of a constitutional law. Our ideals and aspirations made part of the law. Statutory recitals to the ideals and aspirations of the people. It reflects the, it is a reflections or mirror of the whole constitution. Reflection. So when you read the constitution, you will come to know what you are going to get inside the constitution, isn't it? So it's a reflection. When you read the preamble, you get to know what inside the constitution I'll be getting. You can expect, right? So it's a reflection. It is the mirror of the Indian constitution. So I hope you got the clarity, the meaning of the preamble, that it is a prelude, it is like an introductory session, it is a summary, it is a bird's eye view of the preamble. It's the statutory recitals of the ideals and aspirations of the people, because the constitution or the preamble contains the ideals and aspirations of the people. It is the reflection and mirror of the Indian constitution. So now let's see whether, is it mandatory to have, is it mandatory to have preamble? Is it mandatory to have preamble? Like every constitution of the world they have preamble, or is it mandatory? Yes, you can answer this question. You can put it in the chat box. Is it mandatory to have preamble? So the answer is no. It is not mandatory to have the preamble, but we have. Most of the constitution, written constitution, they have preamble. So India also have the preamble. We also adopted basically that we wanted a preamble to the constitution. So it is not mandatory. It is not mandatory to have a preamble, like the 1935 Act, Government of India Act 1935. So before the Indian Constitution came into being, the Government of India Act 1935, it was like a constitution for us. It has, it was the kind of a guiding factor for the law making and all. So it didn't have any preamble. Even some country like, even when unwritten constitutions are there. Obviously, when unwritten constitution are there is no preamble, like New Zealand or United Kingdom. They have the unwritten constitution. They don't have the preamble. But some of the written constitution like Venezuela, even they don't have. Though they have the written constitution, but they don't have the preamble. So it is not mandatory, but the Indian constitution has borrowed, and most of the written constitution, they do have the preamble. Right? So if somebody asks you that whether it is mandatory to have preamble, so it is not mandatory to have preamble, right? And the preamble of the Indian constitution was based on the preamble of the Indian constitution. Preamble of the Indian constitution based on objective resolution which was passed in the Constituent Assembly on 13th December 1946. So the preamble of the Indian Constitution is based on the idea which was mentioned in the objective resolution passed by Pandit Nehru, our first Prime Minister, and he was also the Prime Minister of the interim government, which was created on September 2nd, 1946. So the preamble of the Indian Constitution is based on the objective resolution which was passed by Pandit Nehru on 13th December 1946. So you may remember this date, that's maybe important for your prelims point of view. The objective resolutions, it has contained basically the idea, and after that only our preamble was formulated on the idea based on objective resolution passed on 13 December 1946, right? So having understood the meaning of preamble, and also we have seen whether it is mandatory to have a preamble, and it is based on the objective resolution. So the nature of Indian preamble, what is the nature of Indian preamble? Is it a borrowed one? Is it a borrowed one? Yes. So the concept is borrowed one. Is it a borrowed one? Yes. So we have borrowed the idea of having preamble to the Indian Constitution from US. US, the first written constitution, a first democratic constitution. It started with a preamble. So we also thought of including preamble in our constitution. It is a borrowed concept. Secondly, it is non-operative part of the Indian Constitution. Non-operative part. So when I say non-operative means non-enforceable. It is non-enforceable. Right? Like you can't go to the court of law for getting the provision of the preamble enforced. That in the preamble, justice of social, economic and political is being mentioned. Equality of status and opportunity is being mentioned. And they had mentioned about the fraternity and all, unity and integrity. Though we know these are important part of the preamble and it is enforceable, but you can't go and say that, hey, it is mentioned in the preamble and get it enforced. If it is there also in the other provisions of the Indian Constitution, like fundamental rights and other provisions which are enforceable, then those things can be enforced. But independently, if it is only mentioned in preamble, then it cannot be. If it is also mentioned in other sections which are enforceable, like in fundamental right, you have equality of status, right to equality, Article 14, Article 15, no discrimination on the basis of color, caste, gender, isn't it, place of birth, then of course those things are enforceable. Article 16, particularly in public employment, no discrimination should be there, isn't it? So equality of status and opportunity, it is there, it is being enforced because it is also there in the fundamental rights. But if it is not there in the enforceable part of the constitution, then you cannot go solely that it is mentioned in the preamble, let's get it enforced, then it won't be enforced, right? Independently it cannot be enforced. That's very important because such question has come in the prelims, so be very mindful of that it is non-operative and it is non-enforceable. But if those same provision is mentioned in other part of enforceable part of constitution, then it can be enforced, those portion can be enforced. So that's what you understand, it is non-operative by itself. The provision of the preamble, they are non-operative, they are non-enforceable, neither they confers any substantive power, nor limit power of the government of the state, any power. So the preamble does not limit the power of the government, neither confers any power on the government. The power of the government or power of the state, which had got three organs, executive, legislature and judiciary, right? So each organ of the state, they get power from the separate provision mentioned in the constitution, like the executive. Part 5 of the constitution, chapter 1, that deals with the executive, whatever the power and duties and function mentioned in part 5 of the constitution, chapter 1, that deals with the executive, chapter 2 that deals with the legislature, and chapter 4 that deals with the judiciary. What power, what the functions they have. So the each organ of the state, they derive power from the specific provisions of the constitution, which is mentioned in various parts of the constitution, right? So the preamble neither confers any power, nor limits the power of any organs of the state. I hope you are getting the clarity, isn't it? Because since it is non-operative, right? So since it is non-operative, it does not confers any kind of power or neither limits the power. It is the specific provisions of the constitution which confers the power to the different organ of the state as well as limits their power. So that is what these executive, legislature and judiciary, they derive the power from part 5 of the various chapter of the constitution and not from the preamble, right? So I hope you got the clarity that it is non-enforceable. It can become enforceable only if it is related with any other provision of the constitution which is also enforceable. By itself, it is not enforceable, right? Secondly, neither it confers any substantive power, nor does it take away any power or nor limits the power of any part of any organs of the state, right? So now let's look into the purpose of the preamble, right? So we have just seen the nature of the preamble, which is non-operative, non-enforceable, and it is also a borrowed concept. Now let's look into the its purpose. What is the purpose of the preamble? So the The first purpose of the preamble is that it is the preamble which tells that the entire source of power, since India being a democratic country, the entire source of power lies in the hand of whom? People, isn't it? Because in the very beginning we have seen, we the people of India, isn't it? Hereby solemnly resolve to give India a sovereign, socialist, secular, democratic republic country, right? And then we want to give justice, liberty, equality and fraternity. Hereby we adopt, we, right? So the entire source of power is the people. Nobody is giving the constitution to the people of India. It is the people of India themselves, they are giving the constitution, isn't it? So the entire source of power lies in the hand of the people, right? It's a sovereign constitution and we the people have created that constitution. That is what the significance or the purpose of the preamble. That is what from the preamble we come to know that who willed the power. It is the people. The entire source of power is the Indian people. Secondly, it also talk about the nature of Indian state. That what is the Indian nature? We are democratic. We are sovereign. We are independent. We are sovereign, isn't it? Sovereign, democratic. We are republic. Republic means the head of the state is being elected and not hereditary. And later on we also included India being a socialist and secular. So this was the original part of the constitution. Later on 42nd Amendment Act 1976, we included socialist and secular, and also we included another one, that is integrity. Right? So what is the present position or present the nature of Indian state? We are sovereign, we are democratic, we are republic, we are socialist, we are secular, right? So also remember that originally how it was and after amendment how it was, because this is how the questions in prelims being asked. Nature of, so it is from the preamble we come, what is the nature of Indian state, isn't it? So that is what the significance of the preamble, that from the preamble we get an idea that India being a democratic, it's a republican, it's a sovereign country, and also it is socialist and secular. When from the preamble we come to know what is the date of adoption, when it was adopted and when it was enacted. So we have just seen 26th November 1949. 26th November 1949, isn't it? So it is from the preamble we come to know that what is the date of enactment and adoption of the preamble. So the preamble also talks about what is the date of adoption and enactment. Don't get confused that when the preamble came into force. See, it is not mentioned in the constitution. Remember that. 26th January 1950, the preamble came into force, right? Which is not mentioned in the preamble. So if the prelims question comes like that, was when it was enacted and when it came into force. So remember, this word is not mentioned. Adopted and enacted. 26th November 1949. This is not mentioned because the preamble, because the constitution came into force later on 26th January 1950. So be careful. This is not mentioned. Ideas and aspirations of the people. So the preamble also mentioned the ideas. We have just talked about what is the ideas. The ideas that what type of society we want. We want a democratic, we want a secular, we want a socialist country, isn't it? We want a sovereign, we want republican country. And aspirations of the people, we want justice, liberty, equality, fraternity, isn't it? So that is also mentioned in the preamble. We come to know the ideals and aspirations of the people, or you can say that the ideals and aspirations of the people is being reflected in the preamble. Now, what is the difference between ideals and aspirations? Ideals and aspirations. So, we have just mentioned, right? Ideals and aspirations. So, can you also distinguish what is the difference between ideals and aspiration? So, ideals is basically means to achieve goal, and goal is your aspiration, what you are aspiring. So, what are the ideals? Democracy, republic, sovereign, right? So, these are the ideals, and what is the goals or what are the aspirations we want to achieve? We want to achieve justice, we want to achieve equality, we want to achieve liberty, we want to achieve fraternity. So, how will we achieve? We will achieve all these aspirations through these ideals. Through India being a democratic, sovereign and all, it will help in fulfilling the aspirations of the people of having a society based on justice, equality, liberty and fraternity, right? So, that is what the relationship between ideals and aspirations. So, ideals are basically a path to achieve the goal or aspirations of the people, right? So, I hope you understood the relationship between ideals and aspirations. The constitution also helps in clearing any kind of ambiguity. If there is any kind of ambiguity, and you know who is the interpreter of the constitution? It is the Supreme Court. It is the Supreme Court who will interpret the constitution and finally they will decide. So, if suppose there is certain kind of ambiguity, or there are the provisions of the Indian constitution, there is a lack of clarity, so the Supreme Court can take the help of the preamble. The Supreme Court can take the help of the preamble for the interpretation. While interpreting any other part of the constitution, they can help. If there is any ambiguity, any lack of clarity, they can take the help of preamble to make the things more clear, right? So, the preamble also helps in or utilized by the Supreme Court in interpreting the constitution if there is any kind of ambiguity or any lack of clarity, right? So, preamble gives a very distinct and clear view that what we want, and is also utilized by the Supreme Court in interpreting the constitution. I hope you got the clarity what is the purpose of the preamble. It talks about who is the source of the people, I mean source of power, it is the people, nature of Indian state. It also talks about when it was adopted and enacted, the date, particular date, 26th November 1949, ideals and aspirations of the people, and also it helps in clearing any kind of ambiguity or lack of clarity. The Supreme Court can take the help of the preamble while interpreting the constitution, right? I hope you till here you got a very crystal clear idea, and if with more of revision you will get more and more clarity. And if you have any doubt, I've been repeatedly been telling that if you have any doubt, put it in the chat box, will definitely resolve your doubt, right? Look at the next things what we are going to discuss. Whether preamble is a part of constitution. Now this could be in the prelims and also in the mains they can ask you whether preamble is a part of constitution. So in this context we will consider two cases. One was the Berubari Union case 1960. So in this case Supreme Court said that yes, preamble is very important, very important, and it helps in interpretation of the constitution. It is very significant, but it is not the part of constitution, not the part of the constitution. Though the Supreme Court realized that preamble is very important, very significant, it reflects the mind of the maker of constitution. It also reflects the mind of the makers of constitution. Makers of constitution. The preamble reflects the mind that, you know, what was there in the mind of the founding fathers of the Indian constitution. So it is from the preamble we come to know, isn't it? It reflects the mind of the makers of the constitution. It's very important, but it is not the part of the constitution. It is non-operative, non-enforceable, and hence it is not the part of the constitution. That's what it was being declared by Supreme Court in the Berubri Union case 1960. But in the later case, Keswanand Bharti case, Keswanand Bharti case, 1973. So this is a very, very important case, extremely important. You will be coming across this case many a time, and very important because it was the case where it made the judiciary really very powerful through the doctrine of basic structure. It is this case where the doctrine of basic structure was invented by the judiciary, by the Supreme Court, and it has made the constitution very powerful, constitution and also the judiciary. Most importantly, it has made the constitution extremely powerful, because that is what in an underwritten constitution, it is the supremacy of the constitution, right? You cannot, the government of the day cannot play so much with the constitution. They can bring changes, but they cannot overturn everything in the Indian constitution, isn't it? There are certain things which are very sacrosanct. There are certain things in the Indian constitutions which are had a very key values. They are very valuable, they are sacrosanct, and probably they are universal, right? They are universal thing. So those part of the constitution cannot be changed. So that's why anyway we were talking about the Keswanand Bharti case. We'll also be taking later on. Keswanand Bharti case is extremely important. So in this context also, in the Keswanand Bharti case, what happened? They overturned their earlier judgment of the Berubri case. They overturned their judgment and their idea, and now they said that constitution is a part of, preamble is a part of constitution, because they said that if you keep on changing the other part of the constitution, right? If you keep on changing the other part of the constitution through amendments and all, and you make the constitution very static, even if in the earlier case it was said that it was not a part of constitution, so since it's not a part of constitution, you cannot bring any change in the preamble, isn't it? Since it is not a part of the constitution, it is something very static document. So there can be a clash or conflict, that other part of the constitution you are changing, but the preamble you are not changing with time, or since it is not a part of constitution, you can't even touch it, you can't even change it. Then there can be any classes, with the core values, because the core value is mentioned in the preamble and other provision of the constitution you are changing. So there can be certain kind of classes, isn't it? Suppose like now we are moving more towards liberal democracy, and we are also moving more towards privatization and all, but then we have mentioned India being a socialist country, so we don't know to what extent we will keep to that value that we are socialist country, because in reality we are moving towards more of liberalization and all. So there is a scope, since in preamble is a part of constitution now, there is a scope of bringing changes in that, isn't it? Because we have already brought the changes, considering that time we have added socialist, because at that time socialism was at peak, and India being a democratic socialism, we had adopted democratic socialism, so we wanted to put it in the preamble also that we are socialist, and also we highlighted that India being a secular country, though the other provisions of the constitution reflected that India is a secular country, but we wanted to make it very sure and we included in the preamble that India is a secular, right? I hope you got the clarity what I was talking about, that whether preamble is a part of constitution. So in the Berubri Union case, the Supreme Court said that it is not a part of constitution. But later on in the Keswanand Bharati case, they said that it is a part of constitution, because you cannot keep the two things very different. Preamble totally static and other provisions are keep on changing, isn't it? So make it a part of constitution, then if any necessary changes in preamble, at least you can do. If it is not a part, you cannot do any changes, isn't it? So hence the Keswanand Bharati case, they said that preamble is a part of constitution, right? Now let's look into the second point, whether it can be amended. So we'll look into the same case again, whether through amendments any changes can be brought. So obviously in the Berubri Union case, when it was said that preamble is not a part of constitution, so of course it cannot be amended also. Since it is not a part of constitution, no changes can be made by using Article 368, isn't it? Article 368 talks about the amendment of the constitution. So by following the procedure of Article 368, we cannot amend the constitution since it is not a part of constitution. So that's why classes were happening. But in the Keswanand Bharati case, since it was the Supreme Court gave the verdict that preamble is a part of constitution, and since it is now a part of the constitution, changes can be brought in the preamble. So now the preamble can be amended. So since this Keswanand Bharati case, what we can say, whether amendment can be done? Yes, now it can be done. Since Keswanand Bharati case, but earlier it was not, isn't it? So what is the present position? Yes, the amendment can be done, and after this Keswanand Bharati case only, 42nd Amendment Act 1976 was passed, in which the three words socialist, secular and integrity was added, isn't it? The three words socialist, secular and integrity was added only after the Keswanand Bharati case. Keswanand Bharati case came in 1973 and the amendment socialist, secular, this was added by 42nd Amendment Act in 1976, right? So what is the present position? Is it a part of constitution? Yes, it is a part of constitution. But then do remember the Berubri Union case and the Keswanand Bharati case and the verdict given in both these cases. Whether preamble can be amended? Yes, it can be amended. The present position is that yes, it can be amended. And following that, how many times we have brought amendment in the preamble? Just once. Till now, just once. That is 42nd Amendment Act 1976, and we added three words: socialist, secular and integrity, right? So remember those three words also. So we have done so far the meaning, definition of the preamble, the nature of Indian preamble. We also have looked into the purpose of Indian preamble, and then we looked into whether preamble is a part of constitution, whether it can be amended. So now let's look into few questions on the basis of today's discussion. We'll come with the second part of the preamble. I mean second part in the sense, the second part of the session, because as it's quite a big chapter. Big chapter means it's a detailed chapter. We need to have a very good knowledge. And I'm not only doing from the prelims perspective, but also from the mains perspective. So we'll continue with the various terms which we have mentioned, socialist, democratic and all. What does it mean? What is its significance? We'll do it tomorrow, right? In the second part of the preamble. So on the basis of today's discussion, let's see the previous year question. As I told you that every year, the preamble is very important. Preamble, fundamental rights, DPSP, duties. these 3-4 chapters are extremely important. Almost every year the questions are coming from this section. One of them is the preamble. So on the basis of today's discussion, let's solve the question. The minds of the makers of the Constitution of India is reflected in which of the following? So pretty simple, isn't it? I just mentioned that the minds of the makers of Indian Constitution is reflected in the preamble, right? So very pretty easy question, direct question, and easily you can solve this question. So it is the preamble, because the objective resolutions, which was based on the, what consensus the people had in the Constituent Assembly, that is being included in the preamble. So the makers of Indian Constitution, their mind, you can read from the preamble without, read all the options, but it's pretty direct question. Preamble, fundamental right, DPSP, fundamental duty, read all the option. Don't just looking on the preamble, you tick it. Don't do like that. Please read all the options. Preamble, fundamental right, DPSP, fundamental duty. It's pretty easy question, direct, very easy. But again, as I said, you don't read the first option and mark it. Read all the option, even if you know the answer is very easy and direct. The second question, the preamble of the Constitution of India. The preamble of the Constitution of India is 2020 prelims question. Is a part of the Constitution but has no legal effect. This is bit analytical question, you can see. Is a part of Constitution. Is a part of Constitution but has no legal effect. Seems to be correct, isn't it? Seems to be correct. Yes, it's non-operative. But we have to choose the most appropriate option. Many a time, that is what the questions in prelims are, not always factual, but they are very analytical as well. So you should have a very good clarity. Not a part of Constitution and has no legal effect, this straight away wrong, because we know it's a part of Constitution, isn't it? A part of Constitution and has the same legal effect any other part. So that also we know it is wrong, because the other part of the Constitution, they are quite different, they are operative. Some of them, they are non-operative also, like DPSP, Directive Principle of State Policy, they are non-operative. Fundamental duties, they are non-operative. Fundamental rights, they are operative, isn't it? The fundamental rights, they are enforceable. Other provisions of the Indian Constitution, other parts, they are enforceable, isn't it? So that's, you should know what are enforceable and what are not enforceable. So it's, yes, it's a part of Constitution and has the same legal effect. It does not have the same legal effect, isn't it? Does not have the same legal effect. So that's the reason the statement is wrong. A part of the Constitution but has no legal effect independently of other parts. So if you read the question, there is a tie between A and D, because both seems to be correct. Because here also it is saying that's a part of Constitution but has no legal effect. It is saying only just has no legal effect, but it is saying no legal effect independently of other parts. So if you have to choose, which one you will choose, which is more appropriate? Both are correct, but which is more appropriate? Because the preamble is being used by the judiciary to interpret the Constitution, isn't it? Wherever there is a lack of clarity. So it is definitely has, independently it does not have, I talked, I have already discussed, independently it has no legal effect, but combined with the other part of the Constitution, it does have the legal effect. Like, the secular, it is mentioned in the preamble. In the preamble, it is mentioned democratic, socialist, secular, it is mentioned or not? At the same time, in the fundamental rights also, Article 25 228 talks about that India being a freedom of religion, isn't it? Freedom of religion. So that reflects that India is a secular country. So in that way, when both the things comes together, it can be enforceable. Because in fundamental rights 25 to 28, it is mentioned there is a freedom of religion that amounts to India being a secular country, because there is a freedom of religion, equality of status of all the religion, which shows that India being a secular country. So yes, fundamental right and secular provision in the preamble, both coming together, they have the legal effect, isn't it? So it's a part of constitution, yes, correct, but has no legal effect independently of other parts. If it is combined, it will have the legal effect, but if it is not combined, it has no legal effect. Remember that. So accordingly, answer would be D. The most appropriate is answer D. I know that this question is bit tricky in comparison to the last one, which was straightforward, because the first part it is saying that option A is a part of constitution but has no legal effect. That's what, very plain. We understand very plainly that it is non-enforceable but a part of constitution, isn't it? But when you compare option A with option D, definitely you will have little bit of confusion which one to go, A or D. So in that case, D is more appropriate and more correct. It's a part of constitution but has no legal effect independently of other parts. When combined together, it will have a legal effect. I hope you got clarity, because this type of questions many a time, people or candidate, they get confused, but this is what you have to apply your mind little bit more in an analytical manner, right? So answer is your D. So with this, we are winding up the session. We'll come back tomorrow at the same time and we'll discuss the other part of the preambles. Like in detail, we'll be discussing about the various key terms mentioned in the preamble, like republic, what do we mean by India being a republic, democratic and all. And also we'll try to see if any mains question has come in the previous year. An overview we can discuss there. And any doubt you have regarding today's session, please put it in the chat box. Thank you. All the very best.